Hello everyone, this is Tom Fox and I would like to welcome you to episode 151 of the FCPA Compliance and Ethics Report. Today I have with me Glenn Lammi. Glenn is with the Washington Legal Foundation, a think tank in Washington who, as their name suggests, deals with legal issues. They tend to come in on the side of free enterprise and free trade and file various position papers, and I have written a couple of papers for them. And I thought it was a good opportunity to visit with Glenn, talk about the work of the foundation, how they go about that work, how they utilize lawyers in private practice such as myself and others to help them formulate positions. He also talks about their litigation work, their filings in the Supreme Court, which I found very interesting. The episode comes in at 22 and a half minutes. I hope you enjoy it. Thank you very much.
Hello, everyone. This is Tom Fox, and welcome to this episode of the FCPA Compliance and Ethics Blog. Today, I'm very thrilled to have with me Glenn Lammi. Glenn is the Chief Counsel of the Legal Studies Division at the Washington Legal Foundation. I've had the good fortune to work with Glenn on a couple of papers. One we jointly wrote a couple of years ago on declamations and the publicizing of declamations by the Department of Justice in the FCPA context. We're currently working on a second paper around the internal controls enforcement by the Securities and Exchange Commission. And it gave me an idea that, long overdue idea actually, that I needed to bring Glenn onto the podcast so he could talk about what the Washington Legal Foundation does, his role in it, and how my writing on the FCPA intersected. So with that rather long-winded introduction, Glenn, I really appreciate you taking the time to visit with us.
Thanks, Tom. It's a pleasure to be doing this.
Glenn, could you tell us what the Washington Legal Foundation is, what its mission is, and how you relate to all of that?
Sure. We are a 38-year-old public interest law and policy center. We are based in Washington, D.C., office in DuPont Circle. For those history buffs out there, we occupy the former residence of the daughter of Teddy Roosevelt, Alice Roosevelt Longworth,
wow,
who was quite a Renaissance woman ahead of her time back in the roaring 20s and 30s, and she received every president up until Jimmy Carter, before she sold the building to another business from whom we bought it from, and we're always interested to promote that aspect of us. One, because it definitely reflects the kind of sort of presence that we have as an institution, and also that Alice was definitely an iconoclast of sorts, and we sort of stand among all the public interest groups that get involved in legal issues as a bit of an iconoclast, in the sense that we believe quite firmly in the free enterprise system, and we don't think that capitalism is a bad word, and we certainly don't see eye to eye with a lot of organizations that might consider themselves to be public interest groups, but we do things a little bit differently than some of them.
Well, you're speaking to a Texan, so we certainly believe in free enterprise down here, and one of the things that, like I said in the introduction, we've been able to work together on a couple of papers, and really the first one was in the area of declamations for FCPA cases and the publicizing of declamations, so that compliance practitioners might have a little bit better idea of what the Department of Justice is considering. One of the hallmarks, it appears, of the Washington Legal Foundation is transparency. Do you view that sort of process we went through in the declamation paper as part of your message of transparency in government?
We definitely do. One of the long-standing principles that the foundation has tried to advance through its amicus briefs in federal and state courts, through the publications that we do through programs, is that companies, individuals should have notice of what it is that is legal and illegal. And the FCPA is certainly an area where, because the fines and just the general appearance that gets created if you are prosecuted successfully, or the SEC brings a successful civil action against you, is that you are bribing somebody, you're a corrupt organization. So So it's far more frequent that the targets of the law settle. So there isn't a whole lot of court-made law interpreting the various provisions of the law, which are very broad. The concepts are very broad. So while we're not huge fans of guidance documents, those sort of things, when it comes to regulatory agencies putting out a message about what the law is, we definitely would want to see as many different ways for companies to get a better understanding as to what certain terms mean in the FCPA, and one of the ways for companies to do that is to look at declamation decisions, other sort of documents that the government puts out there. So we thought that was an excellent opportunity to put that message out there, where we definitely regret that that still has not come to fruition, and we certainly will look for other ways to promote that.
Right. I may have gotten a little bit ahead of myself because I didn't really go into what your role is with the foundation.
Well, I have been chief counsel of our legal studies division since 1994. I started at WLF in 1991, right out of law school, and what I do here is primarily recruit attorneys, academics, government officials, judges, others to write for the foundation. The legal studies division is kind of our think tank side, and we're very different from the sort of traditional concept of a think tank in the sense that we look for outside experts to do the writing for us, like yourself. And we've had Mike Kaler, the FCPA professor, write for us. We've had a guy named Homer Moyer here in D.C. with Miller and Chevalier, who's a longtime practitioner and leader in the Foreign Corrupt Practices Act bar, I guess you would call it. And so I recruit the authors. We do all of our editing and publishing and et cetera in-house. I also run the programs that we do, the blog that we have, and we deal with every imaginable issue that affects the free enterprise system from the state, local, and national government perspective. So I'm sort of a jack of all trades and expert of none.
Well, on the process of writing, one of the things I've come to appreciate about your organization is really the rigor you put around the process. And the FCPA is in large part a process, so I'm sort of a process lawyer. But if someone like myself would submit a paper, or you might even request a paper, that's not what gets published. I mean, it goes through a rigorous in-house process. So could you describe that a little bit for us? Because I've been very intrigued with that part of working with you all.
Sure. We certainly, again, rely upon the expertise of our authors in terms of the substance of things. What we try to achieve in our editing process is to make sure that what is written is understandable to our audience. And our audience is somewhat broad. We certainly market our publications to corporate general counsels and public affairs officials at companies, CEOs, but we also send it out to reporters who may be generalists that may not have an expertise in a certain area of law, to law students and others that are involved in the sort of policy process, because we sort of stand at the intersection of law, policy, and politics. So we try to make sure that the educational stuff that we do is understandable to most. So we try to make it as understandable as we can to all of our audience, and at the same time, we try to maintain a certain level of quality in terms of the style of the writing, and we publish in a number of different set length formats and other formats. So we try to make sure everything fit into a certain format. The ones that you have done for us are shorter formats, are 2-pagers called legal opinion letters, and our goal with them is to get as much across as we can in a short space and get the most likelihood that someone's actually going to take the time to read it.
I see. And you also mentioned to me that the foundation filed an Amica brief in the cert petition. Well, maybe I got that wrong. I thought I heard you say you filed an Amica brief, but perhaps you were involved in the cert petition for the Eskenazi case.
That's right. We were an amicus in the Eskenazi case, which came out of the 11th Circuit last year, and it was the first time that any appellate level court had interpreted the term instrumentality within the context of what a foreign official was. And even though there wasn't a circuit split, which is usually a requirement or at least an important factor in whether the Supreme Court's going to grant review to a case, we tried to argue that because so few of these cases get to this level of judicial consideration, and the 11th Circuit itself said it didn't have any guidance as to what that term necessarily meant from other courts, that it was critical for the Supreme Court to take that case up and speak on the matter clearly. We disagreed with the 11th Circuit's decision, which was that the Haiti Telecom Company was an instrumentality of the Haitian government, so therefore payments that were made to certain employees of Haiti Telecom were bribes under the FCPA. We thought that was far too broad of a reading of the statute, but the Supreme Court unfortunately didn't accept review of that case. So that's the leading precedent out there, which makes it that much more difficult for businesses to interpret what it is and who is not a foreign official, which is obviously a key issue under the statute.
Right, and I think certainly, from where I sit, and many compliance practitioners have struggled with that issue, and so to get any guidance was helpful. And I think there was a widespread disappointment from all sides of the spectrum. The Supreme Court did not take the case for all the reasons that you articulated. Plus, there's just such an absolute dearth of case law around the FCPA to have a Supreme Court weigh in on what many of us think is the seminal question of at least this decade of FCPA enforcement. Perhaps would have helped quite a bit, but as the French might say, c'est la vie, and we all moved on with probably Eskenazi will be case law, that issue for the rest of our lives now.
Right.
So let me turn to the kind of public policy aspect of what you guys do and what the foundation does. I certainly understand the how you utilize writings such as myself, by authors by myself, where you try to communicate with your members and raise issues and raise awareness. But on the public policy front, how does the foundation try to influence policy, and are you able to work with our senators and representatives to move legislation?
Well, one of the things that we, as a nonprofit organization, have to do is we have to declare whether or not we're going to lobby as an institution, and we can only use a certain percentage of our funds to do so. We, many years ago, our late chairman and founder decided that in order to be an effective advocate for free enterprise in a space where there wasn't a whole lot of advocates, we weren't going to get involved in lobbying activity. We certainly publish on issues that are of interest to state and federal legislators. We mail our publications to their staffs as sort of educational guidance. We can testify, as we have on several occasions before Congress, if we're invited to do so, or provide constitutional counsel to them. But in terms of specifically advancing specific pieces of legislation, that's something that we sort of leave to the lobbyists and lawyers that make a whole lot of money doing that. Okay.
One of the other things that I'm intrigued that you guys do is you put on webinars on various topics, and are those for the general public, for members, or for how does that part of the foundation's outreach efforts work?
The programs are broadcast live online. They are completely free of charge. We just ask that people register ahead of time, and just like we try to keep our publications short and accessible, we do these as 1 hour long programs on various topics. We try to really drill down on something specific. One of the more recent ones that we did was there's a case that the Supreme Court is going to be considering a petition for review on this coming Friday called Spokio versus Robin, and the issue there is whether or not statutes passed by Congress can create standing for the plaintiffs that bring them, even though under the sort of general principles of Article 3 standing of case and controversy, cognizable injury, there was no injury that really occurred. Nobody lost anything, and there was no harm done. But the plaintiffs have standing based entirely on the fact that Congress defined it as that. And our argument is that Congress can't expand the federal court's jurisdiction beyond what the constitutional limitations are. So we did a program on that after the U.S. Supreme Court asked for the Solicitor General for its views. We had Andrew Pincus, who's a partner at the Mayor Brown law firm here in town.
Right.
He's representing Spokio in the case. So he and another attorney from Jones Day from New York came down, and they did an hour-long program on the Spokio case, the ramifications for that kind of issue. And, it ranges from lawsuits alleging data privacy violations under federal laws to California state statutes, if California and other states embrace the way that we hope the Supreme Court goes. So we've had a really good audience for that one. We've also done programs that were sort of more of debates or discussions on issues ranging from whether the FTC should investigate patent trolls to whether or not the current approach to regulating greenhouse gases are constitutionally appropriate. We get plaintiffs' lawyers and defense lawyers that come together and sort of debate out their views. We found that to be a very effective tool, especially to attract attorneys who wouldn't necessarily have the time to sit down and write an entire paper for us.
Glenn, one of the things noted on the website is the litigation role of the foundation, and really speaks to a broad or a wide amount of public interest litigation. Can you describe the foundation's role in that?
Sure. We started out actually as a litigating group exclusively back in 1977, and the Legal Studies Division was added on 19 years ago. But litigation is still the backbone of what we do. We file probably about 25 to 30 briefs in the Supreme Court each term, both on cert petitions and on the merits. One of the things that we've found is that as an amicus, you can be as or more effective at the cert stage in trying to convince the court to take a case than you can be at the merit stage. You get a case for instance, the Horn case that's being argued on the 22nd involving property rights. There are about 20 amici involved in that case, but to be able to file at the cert stage, there's only a couple. And I think in terms of explaining to our supporters what kind of benefit that we can bring as a third-party group, we've been very effective in helping to get cases up to the Supreme Court. We also file in state Supreme Courts. We file in federal courts of appeals on, as I said, a wide range of issues. Most of the brief writing is done by our two in-house litigators. We do occasionally have pro bono counsel from law firms. We had two attorneys from the Lane Powell firm up in Seattle do our brief in a case called Amica this term in the Supreme Court, which changed the standards for securities fraud litigation suits to some extent. So it's really been a very, I think, effective way for us to affect policy, which is through litigation.
It must be quite exciting for you as someone, if not overseeing, certainly involved in these wide range of issues, to see it across the U.S. and really help it move towards resolution in the Supreme Court if appropriate, and that your insight about being able to help or perhaps be more effective at the Amica stage rather than on the merits, I think is something that is not thought through by certainly corporations. Right,
yeah, and you don't really see companies themselves filing at the cert stage very often. It's an extremely expensive proposition to hire lawyers and law firms to put together a brief and get it up there at the Supreme Court, and often companies will rely upon the trade associations to get involved. Sometimes the trade associations can't get a consensus among their members as to whether or not it's worth it for them to financially invest the money to file. So a lot of times we'll hear from supporters or from trade associations that have members who are supporters telling us about cases that we should get involved in. We're a very small institution. There's only 12 full-time employees, 4 full-time attorneys. So we have to be very targeted and smart about which ones we get involved in and which ones we don't. But we try to get involved in the most important cases in the best ways that we can.
Well, unfortunately, we're nearing the end of our time, but I was wondering if I might be able to ask you a couple of ending questions, which is if someone wanted to work with you or become an author or write for the WLF, how would they do that? And second of all, if someone wants to support the WLF, how would they do that?
Well, my email is glammi@wlf.org. We are always happy to hear from attorneys, law professors, anyone out there that has an interest in working with us just generally in terms of what your issue area is, and we'll certainly keep you on our list of potential authors. If you have a specific issue you might want to write on, a case, a regulation, a development, we always are interested in hearing what people's thoughts are on that. And in terms of supporting the foundation, we're a tax-deductible charity. There is a spot on our website, WLF.org, where you can donate online, or if you want to have us send out a request for support, you can just shoot me an email, and I'll make sure that it gets to the right person here.
And I would just like to add, or perhaps end with sitting in the chair that I sit in, to be able to work with a group like yourself. If there's anyone listening to this podcast in the FCPA or compliance or other space that really feels like they have a message that they want to get out, and it involves free enterprise, it involves the transparency issues that Glenn has talked about in this podcast, I would urge you to get in touch with Glenn, because it gives you a chance to work with someone like himself, Washington insider, if I can use that phrase, yet with the subject matter expertise that you might have, and couple it all with the passion that you might have in an area to work with someone to get your message out. So if you have any interest in talking to Glenn or working with Glenn, I would urge you to get in contact with him, because certainly from my perspective, it's been a rewarding experience, and it's allowed me to reach an audience that I would not otherwise may not have reached because of who the Washington Legal Foundation is and who are some of the folks that listen to. So I just wanted to thank you for that opportunity.
Absolutely. I certainly appreciate it. We very much look forward to getting Tom's second paper for the foundation out on April 24th. And as he said, that's on the tendency of the FCPA to be applied in a strict liability fashion by SEC, and some of the trends that he's seeing in that regard. And we're definitely real excited about getting that one out there.
Glenn, thanks a lot for taking time from your very busy schedule to visit with me, and I look forward to continuing the dialogue.
It's been a pleasure, Tom.